a major decision out of Judge Cannon, the district court in Florida, Dad, both invalidating the appointment of special counsels for two reasons. One, that they don't go through a confirmation process, and that two, so they haven't been, they don't have a process to go through. And two, there is no fund appropriation that Congress sets aside for special counsel. So they can spend unlimitedly as long as the DOJ wants to keep them moving. And so it's like we're not going to have these unchecked prosecutors that are super U.S. attorneys not have to go through this process in the United States of America. But I want to get your take, Dad, on one, the impact of the decision short term is that the charges were dropped against Donald Trump. The next step is, what does Jack Smith do on appeal?
Well, of course, he's going to appeal and it goes to the 11th Circuit Court of Appeals. But, this was the same argument that we raised 6 years ago when we were handling the Mueller investigation. We said that the appointment of Bob Mueller was unconstitutional, that exactly as Judge Cannon said, it violated the appointment clause because, as Department of Justice likes to brag about these special counsels, they have more authority, or certainly the same amount of authority, but with less oversight than a U.S. attorney. And of course, a U.S. attorney to be appointed has to be confirmed by the United States Senate, and the money for that U.S. attorney has to be approved by Congress. None of that happens with the special counsel. So this is an argument that we have raised historically since the Mueller investigation started that we were handling for President Trump. And we said that it was unconstitutional appointment, and we were ready to litigate it. Now, we never had to, because at the end of the day, when the report came out, as you know, there was not only no legal action taken, but the report vindicated the president as regards to the no obstruction and no Russian collusion. Having said all of that, the important part of what Judge Cannon says here is that the special counsel's position effectively usurps the important legislative authority. But also, this is on page 67 of her opinion, she says the virtually unchecked powers given to the special counsel, to Special Counsel Smith under the special counsel regulations. And then she says, and this conclusion is great, since November of 2022, Special Counsel Smith has been exercising power that he did not lawfully possess. And then, of course, the case is dismissed. It goes to the 11th Circuit Court of Appeals. But let me also add that Justice Clarence Thomas, in the case involving the January 6th and the issue of presidential immunity, which was a big victory for President Trump, Justice Thomas, in his concurring opinion, said, hey, Jack Smith has no right to bring anything. He shouldn't be bringing any charges. It violates the appointment clause. So I think this is ultimately going to go to the Supreme Court if the president is not reelected. And I think the Supreme Court's going to say 6-3 or 5-4, no authority for Jack Smith. If Congress wants to fix it, go ahead and fix it, but not as it exists right now. So that I think Judge Cannon made the right decision. And this is obviously a significant victory for the former president.
Why do you think in the past, Dad, courts have been so wary when these challenges have been brought to so quickly dismiss these challenges? Is it because most of these judges come right out of the Department of Justice and it's been business as usual, so they don't want to rock the boat? I mean, we don't see it. It seems like we are on an overload of special counsels right now. Maybe that's the issue too, is that they were not, this has been something that only really came about because of the end of the independent counsel statute. So now we have the special counsel. So do you think it was just a matter of time, or do you think it's just because it's almost being abused against Donald Trump?
Well, I think it's at a point of utilization that we've never seen in U.S. history. There's no statutory basis for it. It violates the Constitution. We've been saying that for years. The courts that have ruled on it, and they act like there's been these, hundreds of courts that have ruled on it, frankly, got it wrong. And I think there is, Jordan, institutional bias. A lot of these judges come out of the Department of Justice, and there's this inclination that the agency is right and that the agency possesses this unlimited authority. And by the way, in light of the Chevron case, which was also decided this term by the Supreme Court, those days are over. And no longer do these agencies have free reign. So this was a double hit in a sense, and I think effectively ends this case certainly before the election. It may end it completely altogether, and I think it's going to have an impact on the case in D.C. If I would file motions to dismiss immediately in Washington. Although that case has got so many problems, I don't know if Jack Smith's going to ever be able to bring it.
Yeah, I mean, they're still dealing with the outcomes of what happened with the Supreme Court case, presidential immunity, and the fact that they'd have to go back through, even if he legitimately was allowed to remain as special counsel, to go back through starting at like a district court level on, okay, what of these acts were actually official acts that could be criminal, what were unofficial acts, what were official acts that again, you can't question those and you can't bring those up as criminal just because you disagreed with the policy decision or the tone of speech that the former president may have used. But on this decision, again, we have seen time and time again, and Dad, we're doing a panel on lawfare this week here at the Republican National Convention. And unfortunately, I think what we've seen is the outcome of extreme lawfare played out this weekend. And I wanted to get your thoughts on that as well.
Horrible situation. And I think lowering the tone is really important right now as we've gone through these events of this weekend and the tragic loss of life in Pennsylvania and almost assassination, and certainly an assassination attempt on the former president. And I think we need to be praying for our country and praying for our nation. I think right now the focus has to be on an election that's only basically 16 weeks away. And you've got a lot of turmoil right now, and we'll see we'll see the American people should be able to make this decision at the ballot box. This should be a vote, not through indictments, not through criminal cases. And I think this is what happened with Judge Cannon is emblematic of what's going on here. Jack Smith is notorious for overreach. I've been saying that on our broadcast for years. He's very good at bringing indictments and not so good at getting convictions or not getting things thrown out. And here, he lost the McDonald case. He lost 9-0 at the Supreme Court. 9-0. Not one justice thought he was right. And on the appointment, on the issue that just came up on the presidential immunity, it was 6-3. So, I mean, he's not carrying the weight here. He knows his whole process is in tremendous jeopardy right now, and that's better for the American people.
Yeah, I mean, I think, again, we do have a call. I want to take it real quick. Joanne in Ohio online, too. Joanne, welcome to Sekiel. You're on the air. I wanted to get this question on Smith.
Hi, guys. Do they have to file a motion to dismiss on this grounds with Chutkin, or can she stay this whole thing so that Jack Smith can't continue to work on it at least?
The lawyers have to file a motion to dismiss. In other words, to get the court to issue an order like this, you'd file a motion to dismiss on the same grounds. Judge Chutkin is also dealing with the reality of trying to figure out this whole immunity issue. Look, the case in New York, the DA's case, is now falling apart because the judge mistakenly let in testimony, which the Supreme Court said he could not, of officials within the White House to testify in the Trump trial there. So that case is going to get thrown out by the appellate division. And then you've got, and we're filing a brief in that, and then you've got a situation with Chutkin. Yeah, a motion has to be made. Clearly the motion has to be made, but I'm sure that's coming.
Yeah, I mean, Dad, we appreciate all of your insight. We are on this. And as you said, that ACLJ is getting involved or has been involved in many of these cases involving Jack Smith throughout this process. And we plan to, if necessary, continue to be involved at the American Center for Law and Justice, not just on behalf of President Trump, but here it's on behalf of the American people and the abuse of the Department of Justice and how we have seen it be weaponized, not just against leading presidential candidates, but also the American people, the whistleblowers that we support, going way back to the clients in our Tea Party cases that we had to represent. So, Dad, thanks for joining us. Logan, I know you wanted to talk to everybody as well.
That's right. We are in the middle of our ACLJ Life and Liberty Drive. So right now, I'm going to encourage you to make your donations at aclj.org or scan the QR code on your screen if you're watching. Right now, I'm going to encourage you, if you can, if you enjoy this broadcast, if you enjoy the legal work we do, if you ever think you could be the person who's going to need us, we'll encourage you right now, donate today to help defend your freedoms. Go to aclj.org and you can have your tax-deductible gift doubled. Right now, for this month, all donations are doubled. And if you're able, become an ACLJ champion, which means you're making a monthly recurring donation. Do that today. We've had ups and downs. We'd love to have more of you join us each and every month at the ACLJ.